Welcome to this episode of our Kuwait Law series. My name is Lulu Al-Hamad. I'm an associate in the Corporate Commercial Division of Al-Tamimi & Company's Kuwait office. I'm joined here today with my colleague.
I'm Khalid Youssef. I'm a senior associate at the litigation practice in the Kuwait office.
We're going to give you a high-level overview of conducting business in Kuwait via commercial agencies. In order to do business in Kuwait, you need to opt for an establishment of a Kuwaiti entity, or you can opt for a commercial agency route. Commercial agencies are regulated under what we call the new commercial agency law, which was issued in 2016, and its executive regulations followed in 2017. This law is to be read alongside the commercial law of 1980. The commercial agencies are defined under the commercial agency law as an agreement whereby a foreign principal will appoint a local agent for the provision of certain services, whether it be a distribution or acting as an agent, or even franchise agreements are governed under the ambit of the commercial agency law. In order to be considered an agent, you need to be a natural person or persons bearing Kuwaiti nationality, or you need to be a Kuwaiti company with local ownership not less than 51%. You must be registered in the commercial register, and you must have the requisite license to carry out the services that you will provide in the commercial agency agreement. The agreement itself needs to comprise a number of elements. The key elements are the information of the parties, the principal's nationality. You need to specify the services that will be carried out, whether it be, for instance, distribution of certain products. You need to specify the term, the territory, renewal method, and expiry, and of course termination. Any other provisions the parties want to factor into the agreement, they can do so, so long as it's not contrary to the commercial agency law.
Right. Thank you, Lulu, for this introduction. Actually, as straightforward as it may sound, commercial agencies usually raise several issues that require close attention, such as the registration of the agency agreement, the obligations of the agent, the conditions for payment of the agency fees, and the term and the termination of the agency agreement as well. And also a very interesting matter is the exclusivity of the agent, which is something usually we see in practice sought by the agent. These all matters are very important that if they are not well considered at the beginning and at the time of the conclusion of the agreement, they may raise problems in the future for the principal. So maybe we can start off with the registration of the agency agreement.
Yeah, registration is key, Khalid, because the agency law specifically states that no dispute will be heard arising out of an unregistered agency agreement. Registration will usually be conducted by the agent, but the principal will need to carry out some procedure elements in its country of residence. So they'll need to have it legalized, notarized, translated, and then they'll send that over to the local agent, who will lodge the agreement with the commercial register at the Ministry of Commerce and Industry. There's also a requirement to deregister, and that should be done within 3 months of the termination of the commercial agency agreement.
Right, yes. As you said, a very important matter in relation to the registration of the agency agreement is the fact that it constitutes actually a precondition for hearing any claim arising out of the agency agreement. So according to the agency law, if the agreement is not registered, the court are probably or not likely to allow any claim arising out of that agency agreement. Also, another important factor here is the fact that the agent may not promote or mention that he is an agent in his documents, letterheads, for example, papers, if the agreement is not registered. And if he does as such, he may be subject to penalties amounting to 10,000 Kuwaiti dinars. But however, there is also another interesting fact here, that we've seen the date of the conclusion of the agency agreement is of a significance. Why? Because we've seen in some case law in Kuwait that the courts, despite what we said, allowed actually claims arising out of unregistered agency agreement. But this we've seen, in most of these cases, they were cases arising out of agency agreement concluded before
the issuance.
Exactly, the promulgation of the new agency law. That's why in this regard, and while assessing a claim arising out of agency agreement, we usually advise that you should pay attention to the date of the conclusion of the agency agreement.
So that takes us on to exclusivity, Khalid. The agency law has kind of abolished the concept of exclusivity. It states that the products or services will not be confined to the agent even if he's exclusive. But we still find that local agents push for exclusivity. Can you give us a little bit more information?
Of course, as you said, this is very expected because usually exclusivity or agent would seek to be exclusive because it would maximize their profits because they would be the only agent for the principal. And the law allows the principal to use the services of more than one agent. And in theory, the principal can actually have more than one agent registered with the Ministry of Commerce, even if it's not, or even if it's agreed to the country in the agency agreement. However, there is an important also factor here, that despite that it being applicable in theory, that they can use the services of more than one agent, if they agree in the contract on exclusivity, this may give rise to a claim for breach of contract from the agent.
And when there's a claim of breach of contract, he'll be entitled to compensation subject to the court's discretion.
Exactly.
So Khalid, with respect to potential claims arising out of agency agreements, our clients tend to point out that the law appears to be pro-agent. The commercial agency law provides that a commercial agency cannot be terminated without breach on behalf of the agent. Otherwise, the principal will be obliged to compensate the agent for such termination. So can you give us some more information regarding compensation and the statutory compensation afforded to local agents?
Of course. That's actually a great question, Lulwa. Because generally speaking, this conforms to an extent to the general rules relating to contracts in the civil law, that any contract or agreement may not be terminated unilaterally unless the parties agree or there is a breach on part of one of the parties. However, as you said, there is a statutory protection here with regard to this agency agreements, that even if the parties agree that the principal is entitled to terminate the agreement unilaterally, the agent is entitled to claim compensation for terminating the agreement before the expiry of its term. A further interesting protection here also, Lulwa, the fact that even after the expiry of the term of the agency agreement, the legislator allowed the agent to claim compensation for not renewing the agreement. So we can have an agreement that is already performed by both parties and the term has expired, but if the principal wishes not to renew, the agent may claim compensation. Of course, this is subject to certain conditions, including but not limited to that there would be no breach on the part of the agent. This is why it's very important to pay close attention when drafting the obligations of the agent in the agreement. Moving on to the assessment of the compensation, it will also be subject to the general rules of assessment of compensation in the civil law, which will the court, will take into consideration the profit expected by the agent should the agreement or had the agreement not been terminated or had it been renewed. Also, the loss that was incurred by the agent. So, in view of that, in practice, we see that the court tend to take into consideration the role of the agent in promoting the business of the principal, the profits accrued to the principal by reason of the works of the agent, also any marketing or promotion expenditures incurred by the agent in performing his works. And one of the other things also is the damage or the effect of the termination or not renewal on the reputation of the agent.
So I think it's fair to say that it's subject to the court's discretion to decide how much compensation should be awarded. There's not a strict formula per se.
Exactly.
Yeah. Khalid, what other issues do you usually see arising out of poorly drafted agency agreements?
That's also another very good question, Lulwa, because, for example, the things that we see in practice, that the manner in which the rights and obligations of the parties are drafted and written in the agreement could actually affect the agreement to a large extent. For example, such drafting could render the agreement a whole different agreement or a different type of agency. And this will, of course, have an effect on the parties' rights and obligations in the agreement. So it's very important to pay close attention also to drafting the agreement and the rights and obligations of each party in this regard, because we have case law in Kuwait where the court characterized the agreement or what the parties thought as an agency agreement to be a different type of agreement. Not even agency agreement, a whole different type of agreement. Because as you also may already know, Lulwa, that in Kuwait, the courts are not required to adhere or commit to the characterization that the parties may bestow upon their agreement. The court is free to characterize the agreement as it may deem proper. Of course, as long as its decision is well reasoned and well founded. Also, another issue that we see in practice that could actually arise also out of poor drafting of the agreement, that the agent may in sometimes be entitled to his commission or his fees for deals or transactions that the principal concludes, but the agent was not even involved in. And this could be managed through good drafting of the agreement. Last thing also, which is very important in this regard, is the statute of limitation. Because depending on the cause of action arising out of the agency agreement, the statute of limitation could actually differ.
So it's clear that the legislator had in mind the local agent when drafting the laws. They have also provided in one of the articles in the commercial agency law that the Kuwait courts will have exclusive jurisdiction arising out of any dispute from a commercial agency, unless you agree to the contrary. So can you tell us how we can escape the application of the Kuwait commercial agency law?
Well, first of all, I mean, this is also a further, as you said, further protection to the agent, because the legislator didn't want the agent to be dragged into foreign jurisdictions where he may not be able to claim his entitlements arising out of the agency agreement. That's why he provided him with this protection that you just explained. However, there is a way to escape this, which is through arbitration, because the legislator allowed the parties to agree to arbitration. And by agreeing to arbitration, or including a valid arbitration clause in the agency agreement, and also agreeing to a foreign applicable law, the parties can escape altogether the application of the Kuwaiti agency law and the jurisdiction of the Kuwaiti court.
Assuming, of course, that the foreign chosen law doesn't offer the same statutory protections as the...
Of course, and also if both the parties are from states where or states are members of the New York Convention, yes, for enforcement of arbitral awards.
So thank you again all for watching. We hope you found it useful, and stay tuned for our further episodes of our Kuwait Law series.
Thank you, Lulu.
Thank you.